afternoon, everybody. Thank you for taking the time out on this very hot afternoon to attend this session on BCRs and our new approach. What I'm going to do today is just talk you through some of the changes we're looking to make. This is off the back of 3 workshops that we ran in June, where we actually walked through some of the documentation that's changed. But we won't be walking through the documentation today. What you will receive today is a canter through of where we've made some changes, why we've made those changes. And I think it's I think what we've done is we've taken some time since leaving Europe just to sort of sit back and reflect and take on board some of the feedback we were getting from the BCR community as a whole, in terms of some of the frustrations and impracticalities around the whole BCR approval process. And where we can and where we could, what we've tried to do is incorporate some of that feedback to give you what we hope is something that is a bit more pragmatic and a bit more practical. But we also we were also sort of very mindful of the fact that it's been some time since the BCR community as a whole has heard from supervisory authorities and EDPB, more particularly around sort of BCRs, although BCRs themselves have evolved over time and their use has evolved over time. So we were also keen to make sure that we, as a regulator, put out updated guidance. And I think it's also important, we felt it was important that what we wanted to give the community back was some transparency and consistent transparency off the, basically. Thank you. So apologies for that, just a couple of technical issues. So I think I'm just finishing off before we get into the slides, just talking about what we want to do is to offer some transparency around sort of when you are in the approval process, where we're focusing our attention. And more importantly, I think we wanted to set out and explain why certain parts of the BCR documentation was of particular importance to us. So what you're about to see now is as I say, a walkthrough of that documentation, and I will be showing you how all the documents have changed. So there is a different application form for completion. The referential tables look different. We're going to be publishing some guidance. And we have also taken the opportunity to sort of set out what we think forms part of the overarching BCRs. But before we dive into those, to the actual documents themselves, I think it's important that we set out what this actually means for organisations and where the sort of onus sits for the BCR holders and applicants. So what we're really doing is putting the emphasis back on applicants to design a privacy programme that fits in with their culture and their business. Quite often what we were finding is that you had some very technical requirements that were quite lengthy, and if you take, for example, the controller referential table, that ran to something like 25 pages of requirements and very prescribed language. Now, some organisations and applicants welcomed that, and others found it very difficult to make the words and the requirements fit in with their style and tone and their way of writing and their way of designing their privacy programme. So what we've done on a go forward is to strip all that out and to give the organisations a freedom to design a privacy programme that meets GDPR, but also UK GDPR, but also fits in with their culture and fits in with sort of their own style. So on a go forward, where our focus very much will be ensuring that the BCRs allow you to be outcomes focused. It's going to be very principles based. You've got accountability at the core. So, for example, the referential tables as they previously stood looked for certain words and certain sentences. We're not asking for that on a go forward. What we're going to be looking for is to make sure that when we look at the whole suite of documents, that you as the applicant and holder are accountable for what you're writing in those documentation, and that you can stand in front of those BCRs as that gold standard transfer mechanism. So in a nutshell, you've got the freedom now to design and tailor those BCRs so that they align with your culture and your overarching global privacy programme. But what we're interested in really is to make sure we sort of come at this with three hats on. We will want to see as a regulator that you satisfy the Article 47. We want to make sure that you're giving effective and enforceable rights to data subjects and to controllers for processor BCRs. We will obviously want to make sure that, importantly, that your BCRs work within the UK legal framework. And that's of particular importance, especially where we've been seeing a number of BCR applications come through trying to piggyback off existing EU BCRs. And some of those, I'm afraid, it's not within our gift to recognise the transfer mechanism. That's a matter for government. But in addition, we have to strip away some of that information to make sure and to see that no rights and protections have been undermined for data subjects or other third parties under the UK contractual legal framework. And it's very important throughout all of this that we continue to maintain high standards of data protection. So before we get into what has changed, we want to just have a quick sort of chat through what's not changing. So all the applications that we've received so far have been under what I would now call our old process. So there is no repapering for any applicant. So what we will do, there's no amendments for you to make. What we're going to do is we are going to assess your application against our revised criteria. That should hopefully speed, when you see the documents in a second, or sorry, not the documents, when you see the sort of new process, which I'll explain in a second, it hopefully will become clearer that we are going to be looking for certain information in certain documents, but not repeated duplicative information. So what you're used to seeing under the old process is information that's appearing in at least 3 different documents. It could appear in the binding instrument, it could appear in the application form, and it could appear again in the BCR policy itself or the documentation that you publish on your website. What we've tried to do is step back from that and say, well, in Article 47, all of this information is important information for the purpose of approving the BCR, and all of this, but not all of this information is needed in all of those documents. And it was clear that organisations were struggling to understand as well why that information was being asked for on a repeated basis. Because often when we are going through the review, it is a lift and shift of the same information, which doesn't necessarily always make sense to its audience. So what we did was we stepped back from the referential tables and the prescribed requirements, and then as a starting point, we tried to work through what information is sought in Article 47 and in which BCR documentation is at best place against which audience it's needed for. So what you will now see is that there'll be certain information that we want in the application form that we don't ask for again in any other document because it's not necessary. We've also changed some of the questions within the application form, and they don't now necessarily correlate back to a requirement in Article 47. What they do is give us the context within which your international data transfers are happening. Often what we were finding as part of the review process is we were second guessing what was going on, and we were trying to second guess where data was flowing, what categories of data was flowing, why it was flowing, where it could be going, who had access to it. So we've removed all of that now and change the questions within the application form themselves to make it a bit more directed and contextual. So there'll be no repapering, but we will assess you against the new criteria. Our preference, you'll recall on the last slide I was talking about making sure that the binding nature of BCRs works from a UK contract law perspective. And in light of that, our preference is to receive, as a binding instrument, is to receive an intergroup agreement as opposed to another type of binding instrument. And the reason why we would prefer to see an intergroup agreement is because of the legal certainty it gives around third-party rights and the certainty it will give to BCR members to ensure that the binding instrument is as effective as it can be. We will consider alternatives on the binding instrument, but just be aware that we will want to see the emphasis and the onus will be back on you as the applicant or holder to demonstrate to us that the alternative that you're putting forward doesn't undermine any of the rights and protections that 47 is trying to protect. So moving on then, the legal entity in the, with the delegated responsibility for UK BCRs, we have set as, and this is always, I believe it's always been the case, but we've given some clarity around this in case there was any confusion, that we are seeking a legal entity that in the UK with that delegated responsibility. And again, it's for the same thought process in mind. You know, we were thinking about the data subject, and a data subject shouldn't be faced with any additional hurdles or obstacles trying to enforce rights under those BCRs. So a data subject shouldn't have to go to another jurisdiction if they wanted to go down the route of formal court proceedings. We will consider, however, because we know there are a few BCR applicants out there that will find it almost impossible as part of their corporate structure to put forward a legal entity for that delegated responsibility. We will consider a branch on a case-by-case basis, and I would you'd see there, put they're subject to certain conditions being met. We have actually laid out 3 conditions for those organisations that want to go down the branch route, and we will come on to them in a second as part of these slides. But in any event, when you see the published guidance, we have given the clarity around what those conditions are as part of the guidance that we'll be publishing soon. And as I've mentioned before, we're not recognising, and we don't have the ability to recognise non-UK transfer mechanisms. So very much so, the UK BCRs are focused with a UK lens, UK focus, and we are pushing back on those BCR applications that are coming in that are trying to piggyback and co-mingle with their EU BCRs for the reasons we've already set out. So for that reason, we are expecting UK standalone documentation that works from a UK perspective. So what is changing? As I say, what you will see published very soon is new guidance for controllers, new guidance for processors. You'll have 2 revised application forms, which are slightly shorter than you've seen previously. There are sections, for example, in the processor application form that have been extended. So there are the section that springs to mind from memory is around data flows and Article 28 commitments that processors have and arrangements they have with their controllers. Now, we're not looking to as part of the BCR approval process, it's not within our scope to look at Article 28 arrangements, and that's not what we're looking to do. But we do remind applicants that don't approach your BCRs in silo, in isolation against other documentation. So if you're offering, which you have to offer, effective and enforceable rights under your BCRs, those rights cannot be undermined by any corresponding Article 28 contracts that you might have in place with controllers. So it's being mindful of the fact that you're putting forward a pack of documentation, but the onus is on you to have assured yourselves that there is nothing that's been put forward that is going to be undermined through other documentation that might exist for other purposes of GDPR. So the other thing that's very important is what's changing is what we've set out in our guidance is we've given clarity of what we believe as a regulator is what constitutes the BCRs. So what we are offering the clarity that the entire suite of documents is what is the UK BCR. So for us, the UK BCRs would be the intergroup agreement, the application form, the BCR policy, and I'll talk about the BCR policy in a second. Any policies and procedures that you've got in place in support. So if you've got policies and procedures that deal with complaint handling or audit or training, that whole suite of documents now is your BCRs. The only thing that needs to be published is, in our mind, is what we're calling the BCR policy. So this is a document that is customer or data subject facing, and the document that is put out for to provide that key information to data subjects you would typically put on your website. And that doesn't now need to contain all of the elements of Article 47. And when we get on, when we talk through the new sort of core referential table, what we've tried to do there is to set out which section of Article 47 should appear in what section of those BCR documentation. So, for example, the corporate structure doesn't need to appear, for example, in the application form, because we need to understand the corporate structure, but the corporate structure doesn't need to be explained away in the same way in the BCR policy, because is that information that a data subject really needs? What is it that the data subject is interested in versus what is it that the regulator needs to know about? And what we've tried to do is reframe the requirements table so that it's now going to be tailored for the right audience. So the BCR policy on a go forward for us is going to be the document that's published on your website. And as I say, it won't necessarily now contain all the things you're used to putting in that document. We will allow for, and when I say it's UK specific, we will allow for those applicants who want control and processor BCRs, we will allow you to put forward a combined binding instrument, and similarly, if you want to, you can put forward a combined BCR policy. What we do expect, though, is that it's clear when you're wearing your processor hat versus when you're wearing your controller hat, and so it must be understandable for a data subject and to us, where as part of the review process, that we understand that X is triggered when you've got your controller hat on and Y is triggered when you've got your processor hat on. If it becomes a bit too difficult for us to work out what's happening where and what data is flowing under which hat, that's when we're going to come back and ask some more questions around that. So, as I said, there is going to be new guidance for controllers and processors. And as I say, what we've done is we've moved elements out of that prescriptive language you're used to seeing from the referential tables, and we put it in high-level guidance. But no longer will you see in any of those documentation a requirement for you to put in any prescriptive language. The guidance now is very high level. It's split into sections, as you can see there. So the controller guidance is going to be in 11 sections. Processor has one more section. And what we've tried to do is highlight in those sections the things we're looking for, what our expectation is and why. And just to remind you as applicants that you have broader GDPR obligations and the interplay between those broader obligations and what you're committing to under the UK BCRs. And I think that's the one message we would want you to take away today, that don't look at BCRs in isolation of everything else you're doing under UK GDPR. Think about what you're putting forward in your BCR application as a privacy programme and against all your sort of obligations under GDPR more broadly, and make sure that there is alignment across that whole suite of obligations. So, as I say, our focus is very much UK focus, UK lens, and we're balancing three competing interests. those are the data subject, you as an applicant and us as a responsible regulator. And what we've tried to come up with is something that we hope balances all of that. Now, it's not going to answer all the questions and all the frustrations that are out there, but it will go some way towards looking at this a little bit more holistically and making sure that some of those pinch points where it's been possible, we've managed to eliminate. So then, as I say, this it's all broken down into high-level sections. We've dealt with the branch position in both those pieces of guidance, and we thought long and hard whether it was actually going to be possible to issue just one guidance for controllers and processors, given the fact that the majority of the requirements in Article 47 are identical, albeit the audience can be slightly different. And we felt it got a little bit confusing, and we wanted to be very clear about what we were looking for when both those types of applications were coming in. So for now, we've left it that there's going to be two pieces of guidance. Now, that could change in the future. You know, one of the things I think we want to make sure that we're clear on is that our guidance isn't set in stone, and it's iterative and it will evolve. So as and when, you know, things change, or there's developments, or there's things that you as a community find don't work, then, you know, it's good we would encourage you to sort of enter into dialogue with us, because what we do want to do is put forward guidance that helps and facilitates those BCR approvals going through quicker and faster and in a more seamless way. And so if that means we have to go away and tweak positions, that's certainly something that we will be able to think about in the future. So as I've mentioned before, we've also now, where as far as we can, we have put forward an alternative on the branch position. So the three requirements I think are going to come up on the next slide in terms of what those three conditions are going to be. But before we move on to that, we have in the processor space, we know that there's been an industry practice that has developed where external third-party controllers are sending data direct to BCR processor members. And what we've tried to do is acknowledge that that is a practice that's developed, and we've recognised it as a practice that's developed. And what we try to do in the guidance is set out and just remind applicants and holders of the wider considerations around that, in that making sure that the Article 28 obligations align with what is going on in terms of how that data is moving. In addition to that, given the fact that we are recognising that scenario, we do now ask some directed and contextual questions within the application form to just give us that flesh on the bone as to what's happening, how it's happening, who is the contract, who is the underlying contract with. So by way of example, if data leaves a third-party controller in London to a BCR member in India, but the contracting party to that service agreement at Article 28 is not the Indian BCR holder, we want to know who is the contracting party, just so we can understand how it then feeds back and relays back into the bindingness of the BCRs, and whether there are effective and enforceable rights. So there is a new section in the application form that tries to tease that information out. And I think before we just pausing there, I think it's important to sort of, when you do have sight of the new documentation, is to not treat it with suspicion. There's nothing that's been put in those applications or information that's been requested that's to try and catch you out. It's actually to just make our life a little bit easier. As I was saying at the beginning, we're often finding ourselves consumed with a whole suite of documents that can sometimes go on for sort of 15 different documents, and then we're trying to second guess what's happening. And we would just really appreciate some help along the way where you just offer us that clarity and you answer some of those questions that come up as part of that approval. And if you can answer them early on, it just saves the back and forth that we find ourselves in. But a lot of the time we're in a back and forth because we just don't understand the context or the flows or the complexity or how everything pieces together. So as I say, it really isn't to catch anybody out. It really is to just give us that context and to get us to approval much quicker. So as I say, in the application forms, what you will see is a shorter application form, but questions that are more contextual and directed. What we don't want to see is the same duplicative information across those whole suite of documents. We want to see documentation that, when pieced together, complements and supports the whole suite of documentation. But as I say, because nobody's being required to read paper, we fully expect certain information that you provided under the old process to appear in duplicative places. We're not going to be focusing on that as long as it appears in the sort of where we now expect it to appear, which we will set out in the referential table. So the referential table will now signpost and tell you where to put something or which document is the best document to house that information. If we see it there, but we also see it somewhere else, we're not bothered that we see it somewhere else as long as it's in the core key document where we expect to see it. So as I said, there's some in the processor application form, there is a bit more that we're asking in terms of sort of around the Article 28 obligations. And we've also sort of taken the opportunity to sort of offer some clarity around the fact that there are some BCR applicants who work under what we call this exporting entity model. And so this is where you've got more than one UK legal entity sending data out of the UK under those BCRs, and each one of those legal entities in their own right are responsible for liability and sometimes the same data flows, sometimes different data flows. If you are using that model, there'll be some key things we're asking for as part of the approval process. So, for example, we're keen to understand in the application form what each entity is doing. So is each entity sending different data to different third countries? Is it the same data? What's the liability model you're proposing? Because some of those entities are still having one backstop, others are not. And what we're keen to understand is, again, are there any, does it affect, how do you achieve bindingness internally and externally when you've got that kind of arrangement? And how do you ensure that data subjects have effective and enforceable rights? So how do you, for example, the kind of thing we've been grappling with under this model is it always clear to a data subject that data has left a UK entity in Manchester sending data into the UK BCRs? Does he know to go, or does he or she know that they need to go and approach that entity in Manchester, or do they need to go and approach the entity in Liverpool or in London? How do you, as the BCR applicant, make it clear to the data subject in that outward facing document that there are different entities sending the data and the data subject needs to go and approach a particular one in order to enforce rights under those BCRs? What we're keen to make sure is where you are operating under that model is the data subject isn't left in a position where he or she is spending days trying to navigate their way around that whole web of information just to work out what rights they have and against who they need to sort of enforce those rights. So in terms of the referential tables, what you will see on a go forward is you'll see a core referential. So we've removed the distinction between control and processor referential tables. You're now going to see two tables, a core table that is completed by all applicants, irrespective of whether you're applying for controller or processor BCRs. This was because we were mindful of the fact that when we were receiving both, it was just almost the same information just being lifted and shifted, and that was just really bogging us down in terms of time on the review. So everyone completes one. If you're also seeking processor BCRs, you will need to complete what we call an Annex 1. And what the referential tables now do is they give you no prescriptive language. We have listed out the different elements of Article 47, and they signpost you as to in which document we expect to see that information. So you will see references to the binding instrument or the policy or the application form or your policies and procedures. There might be situations where we ask for something in more than one area, but we don't necessarily want to see the same information. We want you to take into account your audience. So you might see on the core table that we want to see something, for example, liability. We want to see liability addressed in the binding instrument, but we accept that the binding instrument is usually drafted by lawyers and full of legalese. What we don't expect to see in the BCR policy is that lift and shift. Data subject won't necessarily understand that language. What a data subject needs to know is somebody's on the hook for liability and who they need to go and approach. So it's liability, yes, but the information and the tone and the content and the style in which the information is delivered is the expectation, is where we expect you to sort of tailor it to the audience. So, as I say, the core table now is 5 pages, the annex is going to be 4 pages, and the annex only needs to be completed in addition where you're seeking processor BCRs. So just quickly covering off sort of the binding instrument and the legal entities, as I said, our preference is to see an intergroup agreement. We will consider others. As I say, you can combine your control and processor binding instrument as long as the obligations are clear. If you do want to put forward a branch as opposed to a UK legal entity, these are the 3 conditions that need to be met. So there has to be a written confirmation that the branch accepts service of any legal proceedings, the branch confirms it has sufficient assets to meet those liabilities, and the parent provides some form of guarantee to step into the branch if necessary. What we don't want to see is any accounts or any insurance policies. We just want the confirmation that there is sufficient assets, and that hasn't changed from the position we're in today in terms of sufficient assets. If you are going to rely on policies and procedures and codes of conduct, you use a whole range of terminology around this. It's important that we see how those are legally binding internally and externally. So again, we will ask questions around, well, if this policy changes, how do you make it binding? How does this work? So you can have policies and procedures as part of your BCRs, and to the extent that they're relevant, then think about how you're going to publish those. Not all of your policies and procedures will be pertinent to the BCRs themselves, so that it's not that we expect all of them to be published, but do think carefully about the bindingness and how you're going to make them internally, externally binding, especially when they change. So next steps, we are close to publishing the documentation. It should, all the new sort of suite of documents that I've just referred to are going to be published by the end of the month. We're going to be publishing on our BCR external page, which is just being updated, or will be updated shortly. We did have quite a few questions come through as part of the workshops we've already held, and we are in the process of answering all of those questions, and what we hope to do is to publish all of those answers onto our website, so it will give everyone a bit more context and a bit more information. All the information that you see on the BCR website at the moment is going to still stay there in some shape or form. You're still going to see the list of entities that we've approved. You're going to see the ones that have grandfathered across, that will still stay there, and the new approvals we've been issuing under the UK GDPR. And eventually, as we issue out the approvals, the ones that grandfathered across under the old directive, that list will get shorter and shorter, and eventually there will only be one list, which is a list of UK approvals under UK GDPR. And lastly, we're going to start holding some quarterly BCR engagements, because we do want to engage with you as a community. And if you know, we don't want to work through BCRs in an ivory tower. We want your input, and we want you to tell us what's working and what's not working. And if it means we revisit some of these documents or requirements, it's certainly the forum to raise those issues. And if there's certain other things you want to see on a go forward from us as a regulator, and we really do want to build on that relationship and for it to become more trusted. You know, we don't want, what we would like to do is stop the back and forth and 5, 6, 7 rounds of lengthy debate and lengthy engagement just to get the BCRs over the line. We would like it to be seamless, frictionless, and where we can help facilitate getting you to a quicker approval, we would like to do that. So one of the things we're going to be setting up is these quarterly engagements, and they're not so you have to turn up and talk about anything confidential. Our door is always open to talk about any confidential matters on a one-on-one that are specific to your BCRs, but really to sort of hear where what's working, what's not working, and we would also encourage you to continue raising issues that are outside of our gift with you know, government where, to the extent that they're necessary, and help us understand your flows, help us understand the complexity. So when we have these engagements at government level, we can also raise some of these as the feedback we're getting from you guys as a community. So I would really encourage a lot of you, if you can, to find the time to try and attend some of these engagements. That brings us to the end of the quick sort of canter through where we are and what we're up to. I'll take some questions. We've got 2 or 3 minutes left, so probably only time for one question. Just see if I can pick one out quickly. Are EU Commissioner approved BCRs still considered to be acceptable in the UK? I guess it depends on what you mean by acceptable. We can't recognise EU BCRs, and we don't recognise EU BCRs, so they are still a valid transfer mechanism for data leaving the UK under EU GDPR. If you're looking to use your EU BCRs and language in EU BCRs that is combined, is UK and EU BCRs that are combined, that doesn't work for us. So what doesn't work for us either is where you've got a global policy that has all the common elements that fit across EU and UK BCRs, and then you've got annexes that just deal with the UK or EU elements to the extent that they divert. And the reason why something like a global policy doesn't work in that situation is, our first question is, which supervisory authority is in charge of the content and the accuracy and oversight over the core elements that are appearing in the global policy? Because obviously we are no longer part of a cooperation mechanism. So if there are other ways that you think you could skin the cat, and you know both supervisory authorities are independently can enforce the BCRs in their entirety and not undermine any rights and protections, we are always happy to receive and see what they look like. But our difficulty at the moment is anything that's combined with the EU is the fact that we have no cooperation mechanism. How do we make the UK BCRs effective when they're attached to the EU ones? So it's not that they are obviously still approved under EU GDPR, but for the purposes of, if you're looking for a UK approved set of BCRs, we are looking for UK specific documentation. I think that's probably as far as we can take it today. If you do have other questions, we will take a look at the Q&As that have come through, and if they are in addition to ones we've received already, we will make sure that we've grabbed them and we put them on and we publish a response to them. If they are questions that we've seen as part of the workshops, again, you will see a response to them in due course. So thank you so much for taking the time to hear us on our new approach, and we look forward to working with you in the future.